Welcome back to the Legal Brief, the show where we... No, wait, that's not this one. Oh, all right. Well, welcome back to the Gun Collective. I'm your host, Adam Kraut, and this is the Big 2A. That's right, I'm back. Now, I know you're probably thinking, Adam, why are you here? Aren't you the executive director of the Second Amendment Foundation? Yeah, I am. And I'm here because you guys have been asking for this to happen for years.
It's true.
So I'm bringing you a roundup on all things 2A. That said, let's dive in. Late last week, President Trump issued a new executive order protecting Second Amendment rights, which has led to mixed reactions, ranging from skepticism that anything was going to get accomplished to complete meltdowns that there might not be any gun laws left. That would actually be pretty rad, wouldn't it? The order directs Attorney General Pam Bondi to, at the very least and within 30 days, 1. Review all presidential and agency actions from January 2021 through January 2025 that purport to promote safety that may have infringed on Second Amendment rights. 2. Review any rules implemented by DOJ and the ATF that relate to firearms and FFLs during that same time period. 3. Look at any agency plans, orders, and actions related to the zero tolerance policy that was under the Biden administration. 4. Review reports and other documents issued by the now defunct, thankfully, White House Office of Gun Violence Prevention. 5. Consider the positions taken by the U.S. government in all current and potential litigation. 6. Review the classification of firearms and ammunition. And finally, number 7, review the processing for the applications to make, manufacture, import, or export firearms.
I want to make tanks.
Okay, well, that all sounds like good stuff, doesn't it? After that is done, the AG is to coordinate with the domestic policy advisor to create a plan of action. Now, I know what you're all thinking. But Adam! But Adam! What's going to come of this? Well, truth be told, I don't know. Probably I know as much as you, actually. Assuming the best case scenario, we could see all of those new regulations implemented by the ATF during that Biden administration, like the frames and receivers rule and that arm brace rule rescinded, which means that they're just going to go away. On the litigation side, it might mean that the government will be less adversarial or take a complete 180 on their position that the law they're defending is constitutional. All in all, there's a potential for some good things to happen, but as always, we're just going to have to wait and see. And while we're talking about the federal government, here's a case you may not be aware of that has some interesting arguments from our friends over at the DOJ. In February 2024, Taylor Taranto was indicted on a number of charges, including several NFA violations. That all stemmed from his participation in the J6 gathering in Washington, for which some of those charges were pardoned by President Trump. So, what's so interesting about this case? Well, I'm glad you asked. When Taranto was arrested, he was found to be in possession of a CZ Scorpion with, you guessed it, a brace attached. Now, of course, this was during the time where the government had been sued into oblivion by a number of parties who were successful in securing an injunction against ATF. You're probably asking, and? Well, despite the fact that the regulation was enjoined, the government took the position that it was an NFA violation completely separate from the regulation. In other words, they were contending that the braced firearm, like the one Taranto was in possession of, was just simply an NFA violation. To muddy the waters further, and trust me, this is a little confusing, so bear with me a second here. In its briefing, the government claimed because the rule reflects ATF's best understanding of the statute, those determinations will naturally tend to look substantially like the determinations that would follow from applying the clear framework outlined in the rule.
What?
Yeah, okay, that was a lot to even just try to verbally say. So, essentially, the government's claiming that they can prosecute people for NFA violations on braced firearms, even without the rule because, well, they're the government and they do what they want, right? Taranto's lawyers have moved to dismiss the charge, and that motion's been pending for quite some time now. We're going to see how the court rules on this one. Now, for some gun news from the courts, because that's why you like me, I hope. The gun-owning community has been sitting on pins and needles for weeks waiting for the Supreme Court to give us any news about Snoop, SAF and others' challenge to Maryland's assault weapons ban, coming out of the Fourth Circuit, and Ocean State Tactical, a challenge to Rhode Island's ban on magazines holding more than 10 rounds. We might finally get some news in the near future. Both cases should be distributed this Friday for conference on February 21st. This time of year, when this stuff happens, it's not uncommon for orders to be released the same day as the conference, so we may actually know something about these cases on the 21st, although we may have to wait until the following Monday when that order list is actually published. For some context on this, Ocean State's up on appeal from the denial of a preliminary injunction, and Snope was GVR'd after Bruin was decided, and now has an en banc Fourth Circuit opinion behind it. For those of you that don't remember what GVR'd means, it means that petition was granted, vacated, and remanded, essentially meaning that the Supreme Court said, here you go, lower court, do it again, this time consistent with the opinion we just released. In this case, it was Bruin. And of course, the Fourth Circuit said, the law, perfectly fine. While no one really knows what the Supreme Court's going to do, here's some information compiled by the fine folks over at SCOTUS blog as to what happens when cases are relisted, which is what happened here. And it happened here several times, actually. These numbers are from 2020, but over the 5-year span covered, it was pretty consistent. In the 2020 review, 68% of petitions that were granted had been relisted, and 42% of the relisted petitions were eventually granted. So, what does that mean? One relist doesn't mean the death knell or nail in the coffin for these cases, but as the number of relists go up, the odds for grant go down. Hopefully we'll know more on Friday. Shh. What's that? That's a terrible pun. And segue to mention that Representative Mike Lee has introduced the Shush Act, or in its long form, Silencers Help Us Saving Hearing Act. You know, this bill, why? I don't understand why they try to be creative with bill names. It's stupid. Anyway. The bill, what's it going to do? Well, it would remove silencers from the purview of the NFA and GCA by striking the term from the definition of firearm, and that term being silencer. Additionally, the bill would preempt certain state laws in relation to silencers. Finally, the Shush Act would exempt silencers from the Consumer Product Safety Commission. So, put simply, silencers would no longer be firearms under the law. That would be pretty cool, right? But dueling with the Shush Act is the recently reintroduced and everybody's favorite HPA, or Hearing Protection Act. That's right, we have 2 bills introduced attempting to deregulate silencers in some form or fashion. Unlike the Shush Act, the HPA would not remove silencers from the GCA, but it does take them out of the NFA. Additionally, the bill requires the destruction of any records in the NFA registry as it relates to silencers, and it preempts certain state laws in relation to silencers. We're going to see whether any of these gain any momentum in Congress, but I think it is worth noting for you guys that the Senate is going to pose a major barrier to the passage of either of these proposed laws, since they're going to need 60 votes to end the debate on either bill to actually vote on them. In other words, we're going to need some Democrats. Boo. So I wouldn't hold your next purchase hoping that these laws are going to go into effect anytime soon. Colorado's assault weapons ban has hit a temporary setback as the bill's sponsors pulled it from debate last Friday to address the concerns of Governor Paulus. The Colorado Sun's reporting that the governor is yet to state whether he's decided he's going to sign this bill if it passes, and that he's generally skeptical of policies that target certain models of firearms. But in the same breath, the governor also indicates that he's not completely opposed to it since it didn't target any firearms currently owned by people in Colorado. The bill's sponsors are working to amend the measure to address any concerns that the governor may have and hope to reintroduce it before Valentine's Day because, well, they love you so much. And while one co-sponsor's changed his position based on his constituents' concerns, so apparently calling your representatives does matter, the bill likely has enough support in Colorado's Senate to pass before it would head to the House, where there are definitely enough votes to get it to the governor's desk. This is another one we will be watching. Finally, the Fifth Circuit recently released its long-awaited opinion in Reese v. ATF, SAF, and others' challenge to the federal ban on 18 to 20-year-olds being able to obtain handguns from FFLs. And I gotta say, the timing on this one was rather humorous, at least it was to me, and here's why. The day the opinion was released, I was down at the Fourth Circuit for oral argument in SAF's other challenge to the same law. An hour after we walked out of the argument, the Reese opinion was released, and I gotta say, it's almost as if the Fifth Circuit was trolling the Fourth with the timing on that. So, what did the Fifth Circuit determine? Well, there's a few things. First, it found that the Second Amendment necessarily implies a right to acquire arms. Second, 18 to 20-year-olds are part of the people, the people that the Constitution protects. Third, there's no historical tradition or validity to the historical analogs presented by the government to support their position. And finally, the federal ban on the acquisition of handguns from FFLs by 18 and 20-year-olds is, in fact, unconstitutional. The case was reversed since the district court upheld the law originally, and then it was also remanded back to the district court for proceedings consistent with the opinion. In other words, until the district court issues its order, the law is still in effect and not enjoined. However, with the Fifth Circuit's opinion, we can expect this law to be struck down as unconstitutional. And that's great news for gun rights.